Yes, I do.
And counsel, would you please introduce yourself?
Alex Barker, Adams Kugler, West Palm Beach, Florida.
Thank you. Department?
Yes, my name is Douglas Sunshine on behalf of the department. Before you is a proposed settlement agreement in case number 2010-23877, Department of Health versus James Yelton-Rossello, MD. This settlement is the department's proposed resolution of the 4-count administrative complaint alleging respondent engaged in sexual misconduct, committed medical malpractice, and failed to keep legible medical records. The terms negotiated between the two parties are for a reprimand. And before I proceed any further, this matter was presented to a previous board. The board had rejected the offer and recommended revocation. One of the issues was that a PRN had not been done. I did receive today from counsel a opinion from Acumen that essentially indicates and recommends that the evaluation team recommends that Dr. Yelton enter into a monitoring contract with PRN for a period of time deemed appropriate by the program. Recommends that Dr. Yelton adhere to all requirements in his settlement agreement with the department. They recommend that Dr. Yelton refrain from treating females and that when treating men, he scrupulously practice appropriate risk management procedures to ensure the highest level of propriety and accountability. And lastly, the assessment team recommends that Dr. Yelton practice at all times in full accordance with relevant federal, state, local, organizational, and professional regulations, ethical guidelines, and best practices. They indicate if he is ever unable or unwilling to adhere to the requirements, they recommend that he disengage himself from the practice of medicine immediately until reassessment finds him ready to resume practicing.
And I'm sorry, so we received that when?
I received that today from counsel. I believe he received it
Yesterday afternoon, late in the afternoon. Otherwise, I would have gotten a copy to everyone. I also gave a copy to Dr. Rittenbark this morning.
Thank you.
And so basically, I'm going to go through the terms and indicate how it differs from the previous settlement offer. It was a reprimand. There's now a fine of $25,000. Previously, there was a fine of $20,000. Costs are right now at $26,366.59. A laws and rules course, a drug course, records course, a continuing medical education, which shall include the subject of professional boundaries in the practice of medicine. The previous offer was only provided for 5-hour risk management. There's a temporary restriction that respondent may not examine or treat female patients until such time as respondent has been assessed by and complies with any terms and recommendations made by PRN, and PRN recommends a removal of such restriction to the board. That's versus the previous offer, which was a 1-year temporary restriction that would permit him to come back in a year. There's also the addition of a permanent restriction that provides that when the temporary restriction is removed, respondent may not examine or treat female patients without the presence of a Florida healthcare provider. There is a suspension to the extent that the respondent's license is suspended until such time as he demonstrates to the board the ability to practice medicine with reasonable skill and safety. The board may impose additional terms at the time he seeks reinstatement of his license.
I'm sorry, I think it was a little confusing to those of us sitting here exactly the issues involved as you went. I think you were trying to compare things and it became confusing.
Okay, I can go through just what this offer is. If
sure. Yes.
I'm really reluctant going forward like this. I need to look at this language. I'm thinking, the details of the language is very important. And just to present new alternate language like this before the board, I'm really uncomfortable with going forward like this.
Well, the settlement is a part of the materials that was presented to the board.
There's new language regarding the PRN stuff. And I'm not really...
Oh, in reference to the opinion from Acumen?
Pardon me?
Are you referring to the opinion received today from Acumen?
Yeah, there's new materials received today?
Yes.
Yeah, I didn't even recognize that. I wanted to look at it. We don't have it?
Yes.
Can I move to table this case until till next meeting, till the board has the PRN information, and we've had a chance as well as the attorney.
It's not so much the PRN evaluation, but they're changing the restriction language. Okay, and I don't know.
We can't. I don't feel comfortable evaluating this case without having.
I'll second the motion to table that.
No. Hold on. What's different in this case? What's the difference between what was going on before and now?
What I was presenting is, at the previous board meeting, there was a settlement offer that was rejected.
Right.
And what I was doing was advising you, we were bringing forth a new settlement offer, and I was explaining to you how the terms differ.
That's where I got very.
It was somewhat confusing, I have to say, as we sit here, even as we read.
Yeah, I thought you were changing the settlement agreement on the record.
The new terms of settlement are what is in your board materials as the settlement agreement.
Okay.
I'm simply trying to anticipate that what was different from the old one. I wanted to be able to, as I went through that, and I apologize for the confusion.
It's okay. Counsel.
Yes, thank you. Thank you, board members. In essence, today, Alex Barker, Adams Cooker. What we have is a 4-count complaint related to 4 different patients. What has happened since the time that this case was previously before the board, and I was not present, I've been retained subsequent to that, is a number of things have occurred with respect to the related cases. First of all, there was a criminal investigation that ultimately resulted in no charges whatsoever being filed after insufficient evidence was found by the investigating police. Secondly, there was a civil case that was pursued by 3 of the 4 patients that are referenced in the administrative complaint. That civil case, which I did handle a portion of, I set up the depositions, or I noticed the depositions of the 3 patients. Only 2 showed up, and a 3rd patient that is part of this administrative complaint did not show up. That civil case was ultimately resolved by the facility with no payment made by Dr. Yelton, and Dr. Yelton was dismissed from that case. Next, we have, as far as each patient is concerned, there were a number of inconsistencies that were raised during the depositions in the civil case and that were made to police and so forth, specifically with respect to patient SB. She made claims to police that were inconsistent with the civil case. She was no-show for the deposition, where I could go ahead and question her with respect to the allegations she had made in the civil case. She also had convictions for burglary of a structure, possession of hydrocodone, possession of methadone. These are all felony convictions that patient SB had. The second patient, patient TA, she made inconsistent claims to the Department of Health investigator and that were inconsistent with those that were raised in the civil claim. At the deposition, she did show up for the deposition in the civil case. She admitted to giving false statement to police during their investigation of the case. And as far as patient TA is concerned, she's been convicted of 3 burglaries, a battery, also false report of a crime. She's also been convicted of perjury. The 3rd patient involved in the claim.
I'm not sure, sir. I'm not sure how this is contributing to where we're headed.
I think it's important to understand what has transpired since the time the board considered this case prior to my involvement and recommended a revocation, and what has transpired in the interim to cause the department and myself to enter into this negotiated settlement, and I believe that's why I'm raising these issues. What has changed since the last time this case was before you, and I'm sure one of the 15 members will basically turn to the department when I'm done and say, well, department, what's changed? Why should we change our mind just because Alex Barker's here as opposed to so-and-so that was here before us a year and a half ago? And that's what I'm trying to show with my very abbreviated commentary as to each patient issue, simply to show you that this is a case that is not a straightforward case. It's going to be a very difficult case to present, and these are the issues, very briefly, the issues as to each patient that has developed since the time it was previously considered by the board.
Okay. Have you finished, or you completed, or have you completed it? Have you completed your statement, or?
Well, there's 2 more patients.
All right, go ahead.
And I'll be brief.
But,
The
Mr.
third
Chairman?
patient, may I proceed?
Please.
Mr. Chairman?
Please.
Third patient, once again, inconsistent claims were made to the Department of Health investigator and to the police that investigated that matter. The third patient, JW, has convictions for forgery, battery, and possession of morphine. Finally, the last patient made inconsistent claims to the department as well as to the police. In the case of patient CA, which is the fourth patient as referred to in paragraph 25, she has 2 convictions for theft.
Please stop this.
Yes, yeah.
Mr. Chairman?
Yes, hold on just 1 second. Dr. Zachariah and then Dr.
Counselor, with all due respect to you, I'm appalled that you're sitting here and criticizing 3 inmates. These are not upstanding citizens who come into his office. These are inmates. I don't want to hear about their past history or the current history. It has nothing to do with it. You are just coloring this whole hearing by reiterating the past and the presence of 3 convicts. If they are model citizens, they will be in the prison. He wouldn't be doing those things to those people. So please don't bring up about the past history of these people.
The reason I'm bringing that up is because the issue of whether or not someone is impeachable for purposes of a hearing is something that both the department and the defense in any administrative or criminal proceeding has to deal with. When I was prosecuting for this board and when I was prosecuting for the state attorney's office in Tallahassee, I had to consider the credibility of my witnesses, whether they're patients or otherwise, and that's the only reason I'm bringing them up. I typically do not come in here and in any way, shape, or form disparage any patient at all. However, once again, I feel it's important to understand from the standpoint of prosecuting this case and defending this case, what the individual patients have said to police, what they've said in the civil proceeding, or didn't say because they didn't show, what they've said in this particular proceeding to the investigator of the department, show the inconsistencies, and then also show what they have been convicted of solely because that is something that, whether it's the board or the hearing officer in this particular case, that's something the ALJ will consider in determining the credibility of any witness, whether it's a patient or otherwise.
Dr. Risenberg.
Counselor, you had just suggested that you were informing us of things that had changed since the last time we considered this case, and none of their convictions have changed. So the only reason...
Yes, they have, sir. I'm sorry.
The crimes of which the patients were accused have changed since the last time they came to this board?
Yes, they have. The false report to police officers...
No. You told us what they were arrested for.
No, these are convictions, sir.
Do I need to get the transcript read back, what you just said? You were telling us the crimes for which the patients were in the prison. Do you want me to read? Well, I'll sit here. We can read it back, but if...
I've told you what they were convicted of, whether they were
Right, we knew that.
jail,
Was that different from the last time we were here?
No.
No is the answer. So you asserted that you were informing us what's happened in the interim. In the interim, the people who had been in jail for whatever crime they had committed are the same, they're in jail for the same offense. Well, then would you please enlighten me as to the new crimes of which they've been committed since the last time?
A jail is a place where a lot of people are awaiting trial or awaiting sentencing.
Then for which they've been arrested?
For which they've been arrested but not convicted and innocent until proven guilty.
Right.
I am giving you a number of instances here where these folks have been, since the last time they were here, since the last time this case was presented, and again, I don't know what was presented as far as the patients are concerned at the last time, but that they have been convicted of these crimes, either by way of trial or by way of a plea. And that's why I brought that up.
As one board member, tread carefully, please.
Yes, Dr. Thomas.
Mr. Chairman, let me ask a question to department. Department, couple of things I want to clarify. In the new settlement agreement, there is a lifelong requirement that he has a chaperone. Is that right?
That's correct. The permanent restriction requires...
And a licensed healthcare provider was a chaperone.
Correct.
That's one. Number two, there is a suspension?
Correct.
Okay. And all other things is clear. I mean, I don't know what's the argument here. If at all, the defense is getting a deal from the department here because of the weakness of the witness, whatever reasons. That's why we are yielding. If at all, we are yielding. And so I don't understand why we want to argue this on top of this. And I move to approve this settlement agreement.
Second. So we have a motion to approve, Mr. Telche.
Yeah, the restriction language and suspension language seems a bit
Not
redundant. Just hold on. Seems a bit redundant.
Okay.
Because you're suspending them until they go get a PRN evaluation. Am I correct?
Suspension does, yes, until he can
Until
demonstrate, well, he has to come
right,
in
until he
and
gets a
demonstrate to the
PRN
board.
evaluation. And then at that point in time, when you get the PRN evaluation, you're going to be able to impose probation and other conditions on the probation, which could include the permanent restriction. So it's kind of weird, the language, you get the restriction, and then the restriction's in there until PRN says you can lift the restriction. But at the same time, you're suspending them until PRN comes back and gives you the green, until they give you the green light, you know, and shows that they're able to practice safely, which at that time you can impose the
I thought the restriction was on seeing female patients, but yet there is a permanent restriction, a requirement that he has a female chaperone.
Yeah, I think the restriction was to treat female until deemed
That's
safe,
right.
and then a permanent chaperone.
That's what I was clarifying. So, I mean, if the council is comfortable with the language, I will still stay with my motion.
So, I'm a little confused.
He is suspended until he comes back from PRN,
Yes.
right?
Yes.
And at that time, PRN can, you know, will make the recommendation, and you can impose whatever terms you want at that point in time.
But I like to have, or we like to have, that requirement that a female chaperone be with him when he sees any female patient in his lifetime.
Ms. Gersh.
I'm agreeing with you, Dr. Thomas, except that's not what this settlement agreement says. It just says that a licensed healthcare practitioner, not a female licensed healthcare practitioner. So there are some small amendments that need to be made. I just wanted to point out, I was really concerned about hearing that there was a report received from Acumen, I think that's the name of the company, that PRN has not evaluated yet. And just what was mentioned here at this hearing in regard to some of the restrictions, and it sounded like there were several different restrictions in there. I'm afraid of us getting ahead of ourselves when there might be additional things that we need to impose. Now, if we impose some things here, for example, that permanent restriction with a female licensed healthcare practitioner, as long as the door is open, Mr. Telechia, again, that he can't practice until he comes back before the board, PRN, that we've heard from PRN, and that we have the ability to impose additional restrictions. If we can craft something like that, then I'm fine with this. But I think it's real important what we're going to hear from this report, because just what was stated today leads me to believe we are going to impose some additional restrictions.
Yeah, I think the cleaner way of doing it is just get rid of that restriction.
Okay.
And just put the suspension language and saying that they're suspended until they come back before the board, demonstrate they're able to practice with skill and safely, and at that point in time you have reserved jurisdiction to, based on the PRN evaluation, to impose additional terms, including a restriction or terms of probation, as would be appropriate. This is very confusing. I think it's cleaner just to deal with the suspension language and then impose restrictions if needed based on the PRN evaluation. Now, if you want to have a permanent restriction, regardless of what PRN says, just put permanent restriction, need a chaperone, female, licensed,
please,
and then just keep it like that, and that'll be cleaner.
I think what you're suggesting is to just simply strike the temporary restriction.
So let me Dr. Thomas, let me make sure. Reprimand.
Yes.
Same fine. Cost, laws and rules, drug course, records course, continuing medical education, a permanent requirement for supervision by a licensed female healthcare provider when treating female patients.
Exactly.
Permanent. And document in the record. Okay. And he is suspended until PRN, and then we maintain
before the board. He comes before the board.
Comes back.
And we reserve the right to impose additional terms.
Yeah, someone seconded that. I know earlier.
Second.
Yeah.
Point of order. Did
Yes.
you reject the settlement agreement first? I think you have to do that.
I don't think they rejected the settlement agreement yet.
Okay. We don't reject the settlement agreement.
I thought that was on the table. Let me make sure. But Dr. Beerson actually had a motion to table it, seconded, I think.
Well, my concern still is that no one has seen this PRN evaluation.
We'll see it in the future.
Okay, then I'll withdraw my motion.
Okay, perfect.
And so
do I
first
have a
of all,
motion to reject?
reject the settlement agreement.
You have a motion to reject, second?
Yes, second.
Any discussion? All in favor? Aye. Okay.
I
Opposed?
will repeat my motion again, just what he just said.
What I just said? Okay. So you want me to say it again?
Yeah, please.
Okay, it's a reprimand.
Suspended until he finishes.
A reprimand, $25,000 fine, cost capped at $26,914.08. Laws and rules, drug course, records course, continuing CME on professional boundaries. A permanent requirement for supervision by a female licensed healthcare practitioner when treating female patients.
Suspension.
And suspension until deemed safe to practice with the board maintaining the opportunity to evaluate that.
You would reserve jurisdiction to impose additional terms and restrictions, including a term of probation if necessary.
So we have a motion second. Any further discussion? Yes, Ms. Gersh.
And documented.
I'm sorry, yes,
in
thank
the
you.
record.
In the chart.
In the chart. Dr. Rosenberg.
Yeah, so Dr. Thomas had asked why we're arguing about this, and the reason is because when Dr. Thomas chaired the meeting on August 5th and 6th of 2011, there were only 2 dissenting votes to revoke this doctor's license. The majority of the board actually spoke about this and why they thought they should revoke his license. I don't understand this. I mean, we've said there's nothing that we didn't know last meeting that we now know this meeting. The only thing we spoke about in the transcripts of that meeting in 2011 is we'd like to see a PRN evaluation. Dr. Beerson brought that up. I've had extensive discussions with PRNs since that meeting and now. PRN can tell us about impairment. They can't tell us about character flaws. They are not qualified to discuss character flaws. They are just qualified to discuss impairment issues. I'm going to suggest again, this is not an impairment issue, this is a character flaw. These are bad decisions. Having temporary cell phones that you throw away to evade detection, having testimony that says I'm good 98% of the time, having travel to another city to mail Christmas cards that say XOXO to your inmate patients. These are not disputes. These are not disputed facts. These are facts. This is incredibly inappropriate. How many times are we going to let doctors who cross boundaries continue to practice medicine? You can impose things. How many doctors have we seen today who we've already disciplined, maybe the last one we just saw, twice, who's back before the board again? Oops, didn't work out. Discipline wasn't strong enough. When you have inappropriate sexual relations with the least protected members of our society, these are wards of our state. I know they didn't do nice things or they wouldn't be in jail. They wouldn't be accused of doing bad things. But these are people that the state is entrusted with the care of, and then we subject them to doctors who do inappropriate things to them. And then we say, well, if you promise to have a female chaperone, it'll all be okay. It's not okay. Stop. On behalf of the 19 million citizens of the state of Florida, are we going to tolerate sexual misconduct from our doctors? This may well be my last meeting, and it may well be my last meeting for a lot of reasons, because this is ridiculous. We have to stop this. We went around this table, you all voted to revoke this license with the exception of 2 people. Tell me, I want to hear from my colleagues why 11 of you have changed your mind today when there's nothing new. You can't do this and serve French fries, but you could do this and be a doctor in the state of Florida. I'm ashamed of what's going on here. I have a great deal of respect for your opinions, but I want to hear why they've changed.
Mr. Chairman, I can tell you why I changed my opinion. The reason is, the department clearly says here, we cannot win this case. That's the only reason. Even before, the only reason I mentioned the argument is, the department in the materials they gave it to us clearly says, even though we just recommend revocation as a counteroffer, they say clearly there's no way we can win this case. So what's next left? That's the reason I changed my mind.
Yes, Dr. Zachariah.
The last meeting I was, I felt he should be revoked as well. But let's be practical. If you recommend to revoke his license now, Doctor, you can still practice, right? Or you're on emergency suspension?
He's under an emergency restriction right now, but he has not been practicing for years.
I mean, emergency restriction, emergency suspension.
Restriction, but in essence, he's not able to practice his psychiatry because of it.
I mean, I'm confused.
He's restricted.
Can he practice as a medical doctor, yes or no?
He can, but he has not been able to because of the restriction that's currently been imposed by this board.
Okay. See, from a practical standpoint, if you revoke his license, from what he tells me, he can practice as something else. Right. That's what he's saying. And at the end of the day, the ALJ has to believe the witnesses. Not about this case. I remember years ago about a case of a child psychiatrist from Orlando. Actually, it was in Miami, then went to Orlando. He actually had sexual contact with several minors. Went to ALJ, and the board revoked him. He went to ALJ, and ALJ said none of the minors were credible. As a result of that, he threw the case out. I'm not going to defend for this guy, but the reality is that when the ALJ has to find those witnesses to be credible, and if they find him not credible, you don't know what the outcome is going to be. And again, having said that, I'm not going to sit here and say, you should let this guy go free. But I believe that if you can have a female chaperone in every case that he sees, at least you can protect the public, in my opinion. And at least so far, I didn't hear he had a problem with male patients. He only had a problem with female patients. And so far as he is the patients are protected, and the female chaperone writes down in the chart that she had a licensed chaperone can say that she was present in every chart. I believe that the public can be protected.
I'm still unclear. Maybe Jay can help with this. Is he under, what kind of suspension or restriction is he under?
He's under an emergency restriction that he cannot see female patients, am I correct?
That's correct, but because of the nature of his practice and because of the city he lives in and because of the restriction, it's basically kept him from practicing medicine since.
Okay, so in essence, just to reiterate, so this is a settlement agreement. So if we reject this and go ahead and offer revocation, then the
emergency restriction stays in place.
Right.
And at that point in time, they can go to hearing
or resolve it otherwise. I think we have to take each case on its individual merits. This case is different than other cases. And in this case, I agree with Dr. Rosenberg 100%. I agree with him. I'm going to support revocation.
Yes.
I'm a supporter of revocation as well.
Counsel, do you have something to say?
If I can, yes. The only thing I was bringing up to address the concerns about the PRN. As soon as we signed the settlement agreement, I tried to get Dr. Yelton into the PRN program. I spoke with Debbie True, who I have a relationship with up there, and we deal with a number of physicians in the past, and she said until he gets an evaluation, we cannot enter into a PRN contract. He may not require one. We immediately set him up for an Acumen evaluation, and that was in March 18th through the 21st. We then asked the people at Acumen to please get us a report as soon as possible, and we received the report late yesterday afternoon. Literally, it got emailed to my office. I immediately sent a copy to Debbie True. Gave a copy to, as I said this morning, to Dr. Rivenbark. As far as their recommendation, it was outlined by Mr. Sunshine, but specifically their conclusion is as follows. After a 3.5-day evaluation, they say on page 15, the undersigned and those involved after a complete evaluation, neuropsych, psychiatric, psychological testing, we are of the opinion Dr. Yelton is fit to return to the practice of psychiatry under the restricted license as long as he adheres to the recommendations outlined below. And those were the recommendations made to follow the PRN, or go with the PRN, follow the recommendations of the settlement agreement, abide by all the laws, and have a chaperone. That's what he's doing.
Thank you. We have a motion, Dr. Thomas' motion. Is there any further discussion? Yes.
If I may, Dr. Orr, thank you very much. I would actually speak in favor of supporting Dr. Thomas's position. only because we know what the department told us, what they can do and what they can't do. We've already done revocation before. So I'm in strong support of Dr. Thomas' motion.
Dr. Orr, if I may, as the prosecutor, there is the concern of the credibility of the witnesses. If we go forward to DOA and we do not prevail, we have no ability to restrict his practice. He would then be able to see females without restriction, and that is one of the main bases of the settlement agreement is to be able to ensure that we can restrict.
And I think that was made clear to us with the impugning of the witnesses that we had listened to for the first. Dr. Stringer?
Dr. Thomas, would you consider permanent restriction of female patients?
Put it to the board if they want. I have no objection to that.
So that would be a restriction to not see female patients?
Yes.
Okay. Are you offering that as a friendly amendment?
Yes.
Dr. Thomas?
I'm willing to accept, but I don't know whether it will be practical in this case.
Who's the seconder of the amendment?
Second.
Would you accept that?
Yes.
Okay. Dr. Lodge?
No, I guess that was my main concern. Even though my inclination would be toward revocation because of what the department stated, it is not, because here what we have different from the other, there's a pattern with vulnerable patients that is different. So I would support Dr. Thomas's motion.
Dr. Zachariah?
Mr. Chairman, again, I have serious reservation about this doctor, but I think to restrict him never to see a female patient, I think it is, my opinion, is too severe. I mean, so far there is enough protection. So far the female patients are protected by having another chaperone. And I don't know why you have to restrict him seeing a female patient. Again, I'm only going along with this, at least we know the sure thing right now. The sure thing right now is that if he sees he has all these restrictions we put on him, and that if he ever sees a female patient, he will have a license, Florida healthcare license, chaperone. He writes in the chart that she was present during the time. And that's a sure thing. And there is no guarantee. We can get, you get an A+ in the newspaper if you say, revoke the guy. We all get an A+. But the reality is that newspaper don't control the destiny. The destiny is done by some ALJ. If ALJ finds out that the witness is not credible, I'm telling you, he's going to have an unrestricted license.
Ms. Gershon and Dr. Averill.
Actually, I hear what you're saying, Dr. Zachariah, but when, I don't know if you picked up on this, but what was just read to us is that the Acumen report said that they recommended that the current restricted license continue, and that current restriction is no female patients. So I'm going to assume, and this is only an assumption, that PRN is going to continue with that recommendation, which remembers a provision in our settlement agreement proposal. So I think that hearing that again, I think it's important that, I would like to support Dr. Thomas because the amendment, because if that's what they're already saying, then I think that's a recommendation we should.
Bridget, if the PRO recommends that he cannot see female patients, I'm all for it.
Dr. Abraham?
That's what the report said, that's going to PRN.
Thank you. I agree with Dr. Rosenberg. I would tend to favor revocation, although I am well aware of the challenges that the prosecution is going to have. Therefore, I support the existing motion, except with the amendment of the permanent restriction. The physician cannot see female patients as a permanent restriction. If it's difficult, that's too bad.
Dr. Rosenberg, did you want to say something?
I would just like what Ms. Gersh said to be clarified, because I did not hear that. I heard with the restrictions that were suggested by the new settlement agreement. That's what I heard. So would you care to clarify?
I think the Acumen report, to be perfectly clear, as far as the recommendations that they've made in finding that he's fit to practice as long as he adheres to the recommendations, they're number one, he entered into a PRN monitoring contract, which we tried to do, and will do as soon as they review this report. Recommend that he adhere by all requirements of the settlement agreement because they were aware of all these terms and conditions. Number three, and these are the important three words, at this time, we recommend Dr. Yelton refrain from treating female patients, and then when treating men, he scrupulously practiced risk management procedures and so forth. So at this time, that's what they're saying. They don't say permanently, and that's what I wanted to address, but they do say at this time.
But we are saying permanently as the motion sits currently.
Oh,
Dr. Sugarman, did you have a question, something to say, Dr. Sugarman?
but I'll try to be brief. I agree wholeheartedly with Dr. Rosenberg's settlement. I guess what bothers me is that we're here to do the right thing. The law permits an ALJ to do something else. That's not our problem. We should always do what's right to protect the public.
Okay, the question's been called. We have a motion. I'm not going to repeat it again because I'm not sure I can remember.
Except to clarify that there is a permanent restriction in treating female patients.
Yes.
That's all.
Right, so it's the same terms, but instead you put a permanent restriction from treating female patients, and that the position is suspended until it's a PRN evaluation and comes before the board, and then at that point in time, the board can reinstate them, but may take additional restrictions, including a term of probation.
Exactly.
And the temporary restriction is stricken, just for the record.
Right.
That's right. Okay. Any further discussion? All in favor of that motion? Aye. Aye. Opposed? 1, 2. All right, let's have a hand vote. All in favor of the motion, say aye.
Aye.
Hands. Sorry, hands. Say aye with hands. All opposed?
1, 2, 3, 4.
Okay, motion carries. That concludes this matter.
That's a counter.
That's counter offer.
So you can accept now or take 7 days.
We'll take the 7 days, please.
Can we have cost for the record again?
Yes. Costs at this time are $26,366.59.
Thank you.
Thank you very much, Board.
Okay, this time we'll take a 30-minute lunch break and we'll be back here at 12:59.
And the lunch, if anybody ordered lunch, we have it ready. It's in the Hillsborough room. I think it's next door that way. Also, if you did not lock your computers, please leave them open. IT is going to come and make sure that everything's operational. We know that it's operational, but they're just going to run some tests.
So